I think that we can all agree by now, Nintendo as a company has a complete chokehold on so many of our childhoods. From their versatile consoles to their abundance of very high quality games, it comes as no surprise that they were and still are one of the biggest companies on the planet. But other than having a monopoly on our childhoods, they also happen to be known for something else. Their unparalleled pettiness when it comes to legal matters, suing companies and more often individuals for things that other companies couldn't care less about. Going as far as suing a random supermarket in Costa Rica just because it's called Super Mario, and more recently on October 2025 going after a Reddit mod because he private messaged some people a link to pirate Nintendo games. He's currently being sued for over $4.5 million, and Nintendo says the amount is reasonable and it could have been way higher. You really can't make this up. But other than these comical lawsuits, Nintendo just happens to be in one that is existential to the entire gaming industry. On January 2024, the extremely successful indie game by the name of Palworld would come out. It was obvious from the start that it was heavily inspired by Pokemon, but it didn't infringe on any of its copyrights. Nintendo was so salty that someone would even attempt to make money off of something that looks similar to one of its franchises that it went ahead and sued them in any way they can. Instead of doing copyright lawsuits, they would go with one about patents. From the start, they had the intention of playing this dirty. And recently, in the summer of 2025, they would somehow get a patent approved in the US that would forbid others from making games in which they have a pet fight another pet with something similar to a Pokeball. Something that's been done before by other games countless times and shouldn't be classified as inventive enough to be a patent. The gaming community was in complete shock. This is truly existential because if they win, this will set a precedent in which any company can just somehow get a patent approved in order to destroy any of their competition, especially if they're a smaller developer. The situation is obviously way more complex than this, so that's why I figured I'd have to make a video about it. At the same time, we got a very unexpected revelation thanks to a very unexpected event. Nintendo's biggest weakness that might just stop them from pursuing this lawsuit further. So you already know the drill by now. Let's talk about it. If you were to ask anyone these days about whether there's a good game to play that just so happens to be an MMO, they'll probably laugh at your face before saying, buddy, it's a dead genre. And honestly, they're not wrong. But that's simply because they haven't considered the possibility of an anime MMO coming up soon that's very ambitious. Blue Protocol Star Resonance is a free-to-play open-world MMORPG that has classic MMO elements. You can party up with your friends, encounter dangerous monsters in both dungeons and raids, and of course, you can farm for materials. Certain things though make it kind of special, like how there are multiple classes and you can swap between them anytime. And other than the fact that there are dungeons and raids with so many different enemies, this game places a lot of importance on immersion and player interaction, like being able to dance in a town's fair or setting off fireworks at night with your friends. But while all of that's pretty cool, my favorite part is the very in-depth character customization. You can truly make your character stand out in this game, and to me, that's awesome. And the best part? This game's available now! You'll find the download link as well as limited time codes and launch rewards in the description and pinned comment, so make sure to check it out. Thank you Star Resonance for sponsoring this video. Alright, so to truly understand the gravity of the situation, we have to go back to the basics. What the hell is a patent anyway? Many people would probably define it as a piece of paper that gives you, the inventor, full exclusive rights to make whatever you invented. In reality though, it's more like a weapon. And all we have to do to truly understand it is look at this example of a patent and seeing how the United States defines it themselves. It says, grants to the persons having title to this patent the right to exclude others from making, using, offering for sale, or selling the invention throughout the United States of America. So this isn't about you having the right to make something, this is you having the right to stop others from making something that you invented. Whether you actually choose to pursue people stealing or using your invention though is completely up to you. And in the US in particular, you would have this right for 20 years. But why does this even exist? Well, during the 18th century, humanity witnessed the Industrial Revolution, changing their world forever with the insane amount of new inventions created every single day. Countries loved these new inventions because they kept them competitive and increased their productivity output. So how is it that you encourage brilliant minds to make new inventions? Well, you give them incentive. And that's exactly why something like the United States Patent and Trademark Office exists. Why would you take years, sometimes decades, to come up with a revolutionary invention that a bigger corporation can just steal from you and take advantage of while you rot in a corner? Instead, you can patent this invention, actually directly profit from it, or if you're too lazy, just license it out to bigger companies so that they can use it instead. You'd still get credit for the invention and a whole lot of money in either percentages or royalties or whatever you come up with in the contract. Overall, patents were definitely a good-intentioned invention. The problem was, though, no matter how well-intentioned you might be, when it comes to laws and bureaucracy, it always ended up looking like the fresh launch of a very fun multiplayer game. Initially, it would be a blast until certain players would start to cheese game mechanics to gain the upper hand no matter what. And when it came to patents, unfortunately, it was no different. It didn't take long for certain bad actors to understand that this patent system had loopholes. And when they did, they aimed to take full advantage. A patent troll is actually a real term used in legal circles. In a nutshell, it's a company that literally does nothing, that somehow acquires some patents through some different means, and then proceeds to generate its income by suing other companies claiming that they're infringing on their patents when it comes to their businesses. And one of the best examples of a patent troll is a company that terrorized some of the biggest American tech companies in the world back in the early 2010s. Their name was Lotsys LLC, and they didn't even have a logo. You see, this shell company that literally contributed nothing to society would somehow, through different means, acquire 4 different US patents that were close to expiry. And what made these patents special is that they were all tech-based, but were also extremely vague. And they'd use this vagueness to their advantage, claiming that, for example, because their patent 078 mentioned the transfer of some sort of data from the customer when they're on the website of the vendor, then any company using any sort of chat box on their website owes them money. Yes, it was stupid, but it somehow worked. They managed to sue so many different companies, with the 2 biggest and most significant ones being Apple and Google. Lotsys would send out the lawsuit, and these 2 multi-billion-dollar companies would settle, making a deal with them to acquire their patent through a license, either through a percentage-based revenue share or through a lump sum cash payment. Now at this point, it's understandable for you to be confused. I mean, how the hell does such an obvious shell company with such vague patents successfully manage to extort money out of such big companies? How come there's no pushback? How come they don't even go to trial? Well, that's where things get very interesting. According to the study by the Stanford Law School in 2004, only 0.1% of all patents are litigated to trial. Yeah, that's right. It means that 99.9% of all patents either never have any issues or simply solve things before actually going to trial through settlements. And just in case there's any confusion, the trial stage of things is what you see in movies, right? It's when both sides go through the very lengthy process of presenting their case to a judge. Another interesting thing that came out of the study is that nearly half of fully litigated patents are declared invalid. This distinction is critical to understanding the economic impact of patents. This means that out of the 0.1% of all patents that actually do go to trial, there's a coin flip of a chance that these patents are declared invalid, that they should have never been patents in the first place. This is why when patents are discussed from an economic and practical standpoint, they're seen as a right to try to exclude by asserting the patent in court. This means that just because you're given a patent, it doesn't mean that it's guaranteed to work in court. So if that's the case, why didn't Apple and Google, multi-billion-dollar companies, actually pursue Lotsys? Why didn't they go to trial instead of giving them lumps of money? Well, that's where things get even more complicated. These companies already have a huge horde of corporate lawyers. The problem, though, is that corporate lawyers are seen more like general physicians. You can go to a general physician if you have a cold or something else that's mild, but if there's something wrong with your brain, you need someone specialized in that area like a brain surgeon. There will be way less available and they will cost a fortune more. That's the exact same case with patent attorneys. You could sell both your kidneys on a Friday night, and by next Friday they're already packing their bags going to the next client because you already ran out of money. You'll be bleeding tens of millions of dollars. You'll be losing employee productivity since they work hand in hand with patent attorneys so that they understand the product being sued specifically, and seeing that patent-related trials last an average of 4 years, for 99.9% of the time, it's simply not worth it. This is why it doesn't matter if you're a billion-dollar company or a trillion-dollar company. Unless the patent being infringed is existential or you're 100% sure that you can win, it's better to just give the money that this dumb shell company is asking for and just moving on. But you want to know what's interesting? In May of 2012, Lotsys would sue 55 companies on US soil. 54 of them would of course settle, but only one company decided to go to trial because they just couldn't stand them anymore. And that was the Russian cybersecurity company Kaspersky. Look, they, much like every other company being sued by Lotsys, understood very well that they were bluffing. But unlike every other company, they were willing to put millions of dollars at stake just because they didn't want Lotsys to receive a single dollar. And so after a year and a half, and no doubt millions of dollars down the drain, with a lot of company resources at stake, Kaspersky was able to dismiss the lawsuit with prejudice. And Lotsys had to pay back all the attorney's fees, expenses, and costs that Kaspersky had spent, which meant that essentially this shell company was about to be deleted off the face of the earth. And it was. By 2014, all of its patents had expired, and this shell company simply closed down. Kaspersky had essentially done a huge favor to anyone working in the tech industry, and companies could finally carry on without being constantly harassed. But as we've already established, this was a small shell company specifically designed to extort companies with vague expiring patents. But the question that everyone was too frightened to ask was, what if a company with significantly more resources and one of the most aggressive teams of lawyers ever seen ended up using that same patent troll strategy? Well, it would take a bit over a decade, but we would finally and unfortunately get an answer to that question. And all it took for it to happen was an extremely successful indie game. Game Freak is a Japanese game development studio and one of the 3 owners of Pokemon, alongside Nintendo and Pocket Monster. Pokemon games are extremely popular and sell like hotcakes. They also happen to be always developed by Game Freak. But here's the thing, over the many years of Game Freak releasing Pokemon games, many fans have been getting frustrated over the lack of innovation and this feeling of complete laziness and disinterest. It seemed like Pokemon games had limitless potential with endless possibilities of making different genres and mechanics. And yet, Game Freak just took the boring route every single time, and why wouldn't they? I mean, they sold so many copies, at this point it was a money printer. This is why many of these frustrated fans would find immense excitement when Palworld, a game developed by Pocket Pair, a Japanese indie developer, would be announced to the world for the first time during Tokyo Game Show. Just like in Pokemon, you would collect these cute creatures called pals. There would be everything a Pokemon fan would want, like evolutions, new mechanics, and a bunch of creative things. But instead of it purely being oriented towards children, there was a twist. Guns, rocket launchers, and overall, a bit more of an adult take on something that many people have grown to enjoy. But look, everyone understood fairly quickly, this game was heavily inspired by Pokemon, okay? I mean, one of the top comments on this trailer was, "This is it, this is Pokemon Gun." But you know what? There's nothing weird about that. Gaming has always been about copying things that are successful and making them in your own way. H1Z1 pioneered Battle Royale games and did that after being inspired by community mods in the game Arma. And this chain would continue until we'd get to a game like Fortnite, making a Battle Royale game in their own way while clearly being inspired by their predecessors. This is what gaming has always been about, and at this point it came to be expected. What no one was expecting though, including Palworld's own developers, was the massive success they'd receive overnight on the game's release. The game would release in early access on the 19th of January 2024, and within just 8 hours they would sell over 1 million copies. For an indie game, that is mind-blowing, but they were only getting started. In under 2 weeks, they would sell over 12 million copies on Steam alone. Bear in mind, this game was also on consoles. And within barely a week of releasing, they would have over 2.1 million concurrent players on Steam, beating all sorts of records and being in the top 5 most played games on the entire platform. At this point, it was extremely hard to ignore this game's success. Everyone in the gaming industry knew of its existence, and it became an incredible success story. But, of course, you already know the drill by now. When something finds such immense success, you start to attract a huge amount of people scrutinizing what you've made. And sometimes, those people don't always have the best of intentions. It wouldn't take long for people to start making very direct comparisons of some of the pals in Palworld versus Pokemons. I mean, look, everyone understood that Palworld was already quite inspired by Pokemon, but these comparisons would blow up beyond proportion to the point where something unprecedented would take place. The Pokemon Company International would personally make a statement, something that you see extremely rarely, in which they would very obviously, indirectly call out Palworld personally, saying, "Inquiries regarding other companies' games. We have received many inquiries regarding another company's game released in January 2024. I mean, come on, that's literally Palworld. We have not granted any permission for the use of Pokemon intellectual property or assets in that game. We intend to investigate and take appropriate measures to address any acts that infringe on intellectual property rights related to Pokemon. We will continue to cherish and nurture each and every Pokemon in its world and work to bring the world together through Pokemon in the future. Signed, the Pokemon Company." Now look, the reason why the statement was so significant was because the Pokemon Company never spoke personally about such things. And I mean, why would they? Yeah, they're owned by 3 different companies, but Nintendo, even though owning just 1/3, actually owns all the copyrights involved with anything related to Pokemon. This is why they typically do the suing for them. And so it was official. After this very rare statement from the Pokemon Company International, it was clear. Palworld had a huge target on its back, and Nintendo was aiming to take full advantage. They were very salty about seeing a game take so much inspiration from Pokemon and being so extremely successful. And on January 25th, 2024, barely a couple of weeks after Palworld had come out, and on the same day the Pokemon Company International would make its very rare statement, Nintendo would formally announce that they would begin an investigation into Palworld and its assets. But what does investigation mean? I mean, they didn't really infringe directly on anything Pokemon related. People were hoping that this would die down, that it just proves to be some sort of misunderstanding. What they could have never predicted beyond their wildest dreams, though, was that a company like Nintendo was about to take direct inspiration from shell companies such as Lodsys. Almost 9 months after the Pokemon Company International would announce that they're taking steps to investigate Palworld, on September 19th, 2024, Nintendo would announce that they're officially filing a lawsuit for infringement of patent rights against Pocket Pair, the developer of Palworld. The statement, however, didn't specify any of the patents that they're actually suing Palworld over, and on the same day, Pocket Pair would also make a statement saying that, hey, we're aware of the lawsuit, we've began the legal proceedings and investigations, but we're literally unaware of the specific patents we're being accused of infringing upon, and we have not been notified of such details. In other words, Pocket Pair was as clueless as we are about what they were exactly doing that was illegal here. It would only be almost a month later, on November 8th, 2024, that Pocket Pair would finally understand what the patents they were infringing upon allegedly were. This is when the entire gaming community as a whole would be completely baffled by how the 3 patents in the lawsuit were all filed and approved after Palworld had released. That's right, Nintendo was suing Palworld for patent infringement on patents that they had presented to Japan after Palworld had released. Now you're probably wondering, Mugen, how the hell is that even possible? Well, we'll get to that, but for now, let's take a look at these patents. Well, first things first, just in case this wasn't obvious, Nintendo was suing Pocket Pair in Japan since they were both Japanese developers, hence why we're discussing Japanese patents. 2 out of the 3 of these patents involve you using a Pokeball. In Pokemon games, you use a Pokeball to either capture a creature or summon a creature. In Palworld, there are no Pokeballs, but there are Pal Spheres. Yes, of course, they're a direct inspiration of Pokeballs, but this mechanic wasn't patented at the time. The 3rd patent was about flying your pals in the air, but this one was very specific. It was about how when you would fall in Palworld, you could summon your pal to pick you up mid-air. And of course, just like the other 2 patents, Nintendo had patented this in 2024 after Palworld had released. So how the hell is this even possible? Well, it's simple. That's because these 3 patents were filed as divisional patents. What the hell is a divisional patent? Well, here's a rocket ship. Let's say you're SpaceX, you want to patent this rocket ship. Great. You make a general patent that pretty much covers this entire rocket ship, every component, but you don't delve too much into details. Now let's say you file that patent in 2020. A few years pass by and you finalize the design of the rocket boosters. You're happy with it and you're ready to patent that too. This is when you would create a divisional patent. It would be its own patent, sure, but it would fall under the general patent of the rocket ship. So even though you would be filing this, let's say 3 years later in 2023, it would still be a part of the general patent from 2020 that covered generally the entire rocket ship. Now in this context, of course, it makes total sense. But when it comes to software, patents get very tricky, and Nintendo knows this. This is why they're taking full advantage. The original and more general parent patent was filed in 2021 by Nintendo. It had to do with the many generalized game mechanics involving the game Pokemon Violet and Scarlet. These 3 divisional patents that were filed in 2024 aimed to complete the more generalized parent patent from 2021. So yeah, you see where this is going, right? Nintendo was playing dirty, and they had no intention of backing down. But unlike Lotsys, who was a shell company just looking to get quick money from big companies, Nintendo wasn't in this for the money, come on. Yes, technically speaking, the injunction filed against Palworld wanted 5 million yen plus late payment damages to both the Pokemon Company and Nintendo. And yes, since Palworld had released, they almost made $500 million in gross revenue, but more specifically, $139 million in net revenue after fees and taxes. But for Nintendo, the money was nothing more than a formality. They genuinely didn't care how much money they got from this lawsuit. I mean, we're literally talking about a company worth over $100 billion. The money generated by Palworld to them was like a penny. So what exactly was going on here? Nintendo on September 19th, 2024 had effectively signaled to the world that they only wanted a trial out of this. Yes, what Apple, Google, and other billion or even trillion-dollar companies feared the most. They were heading straight for the jugular here. And other than the fact that these patents were made after the fact, after Palworld had released, showing us that they had very direct disdain towards the company, what a normal company in Nintendo's shoes would have done is do some sort of patent licensing agreement if they were really that pissed. They would just sit down with Pocket Pair, tell them, hey, listen, come on, we know that you were very heavily inspired by Pokemon, let's not be around the bush, we don't want to take this to trial, just give us a percentage of your sales and we'll call it a day. And most likely, Pocket Pair would have probably said yes, because they're also not interested in going to trial. I mean, guys, from an interview with the CEO after the game had come out, he revealed that this company had 10 employees and hired 40 employees before releasing the game. This is a company that has 50 people. Sure, they made over $100 million in revenue, but they were going up against a $100 billion company that has a huge team of lawyers in every region of the world that specifically work closely with its developers, understanding game mechanics and knowing exactly how to sue and defend. And now if we reference back the Stanford Law School study that was specifically done in the US, we could definitely argue that these patents from Nintendo are very vague and probably won't make it to the end of the trial. But you see, that would only be a problem for Nintendo if they actually aimed to win or lose the lawsuit. They didn't. They know very well, more than anyone, that patent litigation is way too expensive in terms of money and time. So to them, this wasn't about money. This was about crushing Pocket Pair until there was nothing left. This was simply about sending a message. Compete with us and you're dead. And unfortunately for Pocket Pair, they would realize this actually very quickly after the lawsuit would begin. Barely 3 weeks after understanding what the patents they're being sued for were, Pocket Pair released a new patch for Palworld. It fixed some bug fixes, added some features, but also removed a very integral part of gameplay. You could no longer use Pal Spheres to either capture or summon your pals. If you wanted to summon them, they would just simply appear next to you. And this, for many, heavily impacted gameplay because it was a very unpleasant way of calling them. And more recently, on May 8th, 2025, you could no longer summon one of your pals when you're in midair. Instead, to not die from fall damage, you would have to equip a new item called the Glider. As a reminder, the lawsuit was presented on September 2024. It hadn't even been 1 year, and Palworld was already forced to make changes as this lawsuit is still ongoing. Now, according to a Japanese patent attorney, he points out that these changes by Pocket Pair are not in any way an admission of guilt, adding that Pocket Pair is following the standard three-pronged defense against patent lawsuits, which is to deny infringement, argue that the patents are invalid, and avoid infringement through design changes. He also noted that Nintendo does not have the upper hand, as there seems to be a fierce back and forth with Nintendo pushing for patent infringement and Pocket Pair pushing for patent invalidity. So make no mistake, they are deep in the trenches fighting right now. And when this Glider update came out, Pocket Pair would also make a statement, explaining to everyone that yes, these changes that were being introduced into the game were a direct result of these ongoing patent lawsuits. They would then go on to say that these changes hurt them as much as they hurt the fans, apologizing to them. I think it was at this point that people truly realized, wow, this really isn't going to be easy at all. Because this whole thing was anything but straightforward. Nintendo wasn't just playing dirty, they had pretty much stooped lower than a company like Lotsys. On July 2025, so fairly recently, they rewrote a patent in Japan mid-case during the ongoing lawsuit against Palworld. Nintendo was getting desperate. Its flying patent wasn't really holding up as well as they wanted to against Palworld's defense. So in one of the first cases some lawyers have ever seen, they used some very weird language in the patent update, adding the term even when, making a lawyer say, "I've been following patent litigation for 15 years and have seen many claims that were amended, but I've never seen even when or even if in a patent claim. It's bizarre." Nintendo is essentially using this language to try and complicate things and make this patent even more vague than it already is. This is because, as I said, their intention was to prolong this as much as possible, to drown Palworld in paperwork, hoping to bankrupt them pretty much and erase them from existence. But this dirty tactic was nothing more than them actually panicking. Pocket Pair was actually doing a pretty damn good job, coming up with a lot of examples that show that even before 2021, all of these patents were already used by prior games. So if Palworld can actually survive this lawsuit and see it till the end, even though it might take a very long time, they might not only end up winning, but make many of the patents Nintendo had filed to be invalid. Thing is though, you'd be naive if you thought that it was going to be that easy with Nintendo. Their legal team played dirty, and just as Palworld was starting to gain some sort of a fighting chance in Japan, Nintendo was aiming to create a war on two fronts. Ever since 2004, the US Patent Office has been absolutely swamped by a huge backlog. Barely able to keep up, being understaffed. I mean, you already know the drill. This is just another government agency in a first world country in the 21st century. But due to this understaffing and the fact that they have so many applications to go through, there's historically been many people who criticize the Patent Office for being pretty inconsistent with their decisions on what is a valid patent and what isn't. This inconsistency would initially show itself in February 2025 when Nintendo was gearing for a US patent lawsuit against Palworld. They would present 23 patent claims, but 22 of them would be rejected, with the argument that they simply weren't inventive enough. They were used before already by other games. But when it comes to Nintendo, this isn't really enough to discourage them. They were not only planning to fight these rejections, they had more in store. That's just how much they hated Palworld. Nintendo's efforts in the US would finally bear fruits on September 2nd, 2025, when the United States Patent and Trademark Office would grant them a patent so vague and so unoriginal that it would absolutely shatter the gaming industry in shock. This patent was filed in 2023 and was approved in 2025. In a nutshell, this patent is about a sub-character, so like a Pokemon. The patent dictates that you must be able to summon the character. It specifies things like summoning it specifically to fight, even detailing things like sending the sub-character in a direction specifically to start an automatic battle. And no, you're not the only one here that thinks this is crazy. This is not only extremely vague, but it's been done multiple times before by other games in the past. By 2025, or hell, even when this was filed in 2023, this was in no way inventive. This wasn't some sort of breakthrough, right? This would cause many patent lawyers to see this in the US and say things like, "This has been an embarrassing failure of the US patent system." I mean, even the former Pokemon Company head lawyer said, "I wish Nintendo and Pokemon good luck when the first other developer just entirely ignores this patent." Everyone was completely shocked at the fact that something like this could actually pass, and if someone wasn't convinced yet, if someone was a huge Nintendo fanboy that truly didn't see the problem, this was it. This was the point in which you would see that this definitely feels like a punishment specifically for Palworld. Because if Nintendo truly cared about this mechanic, then they would go ahead and sue Blizzard over their 2011 Battle Pets minigame. Even back then when it came out, it was very clearly inspired by Pokemon. It was obvious to everyone. So at this point, it's obvious this is a punishment against Pocket Pair. But as far as their patent goes, seeing that there's very clear past examples dating more than a decade ago, how the hell did it get approved anyway? Well, to really be able to explain to you what's going on right now, we need to briefly go back to what a patent actually is. As we saw earlier, the realistic approach to what a patent actually is a right to try to exclude by asserting the patent in court. We've already established that only 0.1% of all patents actually go to trial, so one could say that many of them are actually invalid. They've just never been contested in court. And the US Patent Office is constantly swamped by a backlog. So with all these things combined, now let's think of the employee working at the US Patent Office. You see a software patent, and it technically ticks all the boxes needed to be approved. You have two choices. You either approve it, move on with your day, go back home, see your family, have dinner and sleep, or you can be a smartass and contest it, knowing that the company's gonna contest your decision immediately. This means that the nice lunches and dinners you were getting with Nintendo's lawyers that you've built a friendly relationship with would all disappear. And this also means you've just unlocked yourself more work. Why the hell would you do that to yourself? You know what a patent actually means. It's the right to exclude others. And you know what? If it's a bogus patent, then hey, let them figure it out in court. Either way, it wouldn't be your fault. This is exactly why Nintendo was able to do what it's doing and why patent trolls exist to begin with. But if you thought this was bad, then wait till you see what Nintendo's doing at the same time. Yes, believe it or not, it does get more ridiculous. Nintendo has always hated mods, even though they're created by players and have no affiliation with the games themselves. They've always made it a point to target the game developers themselves as if they were the ones to make mods that infringe on their copyrights. Something completely unreasonable that has always pissed off people who valued creative freedom, especially in the modding community. While you see, one of the very creative ways Palworld is pursuing Nintendo's patent claims is by showing that the things being presented in the patent were already done by people beforehand. This is the easiest way to invalidate a patent. One of those prior examples that Palworld is pushing is a mod called Pocket Souls for Dark Souls 3 that uses an extremely similar mechanic to their whole Pokeball patent. Even though it's not a standalone game and a mod, it's showing that someone already came up with this idea back in 2020, even though the parent lawsuit of the Pokeball mechanic was made in 2021. This technically goes against what a patent is. You're not the first one that came up with the idea, even if you just so happen to be the first person to actually file a patent for it. It doesn't work that way. Well, what was Nintendo's argument here? Mods aren't real games. This is coming from the same company that has personally taken down mods for other games and its own games for copyright infringement. This is very clearly showing us that they have such a hate boner for Pocket Pair that its own lawyers are starting to self-destruct. I mean, now in Japan, they're in a catch-22 situation. They either admit that mods are actual games and invalidate their patent, or they don't, and they invalidate all the lawsuits of people who are making mods of their copyrighted material in other games. It's a lose-lose situation. That's how clouded by hate they are right now in regards to Palworld. It's ridiculous. I mean, by this point, it doesn't take a genius to understand this is an injustice going on right before our very eyes. How can Nintendo keep getting away with this? And are you, the viewer, just meant to sit down in despair watching this all unfold without being able to do anything? Well, no, you can do something, and believe me, people have tried. In anticipation of the Nintendo Switch 2 console coming out, many people have vowed to boycott over Nintendo's anti-consumer practices, since they essentially want to monopolize anything that has to do with capturing cute creatures in a game. Well, the console released, and it ended up selling over 3.5 million units worldwide in its first 4 days, becoming the fastest selling Nintendo hardware ever globally. Yeah, that boycott failed spectacularly, and this happened in the middle of their Palworld lawsuit. It seemed like Nintendo was hated worldwide over its anti-consumer practices, but at the same time, nothing could stop them from selling pretty much anything. But hold on, before you fall back into utter despair, I have some good news. Recently, we've come to find that the invincible Nintendo actually has a very big weakness. That's right, they have their own version of Kryptonite, the one thing that scares them and can take them down, and the way we found this out recently was in one of the most unexpected ways possible. On September 23, 2025, the Department of Homeland Security of the United States of America would post a video compilation of illegal immigrants, or as they like to call them, illegal aliens, being arrested. The caption was, "Gotta catch 'em all." The music playing was the music from the Pokemon show, and if that wasn't enough, in between cuts of people being arrested, they would start showing footage from the anime itself. Oh, and to really drive the point home, they would also create literal Pokemon cards of some of the people being arrested, giving them all 1 HP, showing the word illegal on the top left, and their description would be the crime that they committed. The official Customs and Border Protection account of the United States would also reply to this post with a gif of Pikachu, saying, "Border Patrol's newest recruit." Now look, this was absolutely unprecedented, right? I don't think a government has ever so openly infringed on copyright like this on such a massive scale. But there we had it, right in front of our eyes. The reactions, of course, just like anything political in the United States, were mixed. Some people liked it, others not so much. And all of a sudden, you had a sizable amount of people that wanted Pokemon to sue the Department of Homeland Security, and I mean the US government, for copyright infringement. This was such an easy lawsuit, guys. I mean, come on. And knowing how trigger-happy Nintendo's lawyers were, I mean, come on, this was bound to happen any time now, right? People were brought to believe that this is what was going to happen. Because on the next day, the Pokemon Company International would make a statement saying no, they did not give the US Department of Homeland Security any permission to use any of its copyrights in that video. But on that same day, we'd also get another piece of news that would disappoint the fans that wanted Nintendo to sue the US government. The former legal chief of Pokemon would reveal this in an interview, saying, "Even if I was still at the company, I wouldn't touch this, and I'm the most trigger-happy chief legal officer I've ever met." Specifically, he would give 2 reasons. The first one is, many of the executives of the Pokemon Company in the US are on green cards. If they were to sue the US government, they would probably lose their green cards. But the second reason he gave us was a bombshell, something that I don't think he understood how big of a deal it was. He'd say, think of how little you see the Pokemon Company International's name in the press. They are insanely publicity shy and prefer to let the brand be the brand. This statement maybe wouldn't strike you as such a big deal. In reality though, this is him openly revealing Nintendo's Kryptonite. You see, there's a reason Nintendo takes on all the lawsuits by themselves. They never involve the Pokemon Company International if they don't have to. It's because they're used to being hated. They know it doesn't affect their business, and they just frankly don't care. On the other hand though, think about it. How many times have you seen the Pokemon Company International directly and personally involved in lawsuits? The reason why their statement about Palworld was so exceedingly rare is because this never happens. They only did it in an effort to legitimize the lawsuit that would eventually come from Nintendo. But overall, they care deeply about their reputation. This is something that people like Andrew from the channel Legal Mindset have sought to take full advantage of, making sure to rile up social media criticism of the Pokemon Company International, not just in English, but also using Japanese hashtags. He, as well as many other people, believe that if Pokemon Company International receives enough backlash on social media, more specifically, while being given the impression that they're becoming unpopular in Japan, then Nintendo will finally back off from Palworld and stop trying to make them some sort of example while trying to monopolize an entire genre of games. The biggest threat here is Nintendo somehow succeeding in its goals, either by bankrupting Palworld or by somehow using its huge influence in Japan to win the lawsuit. If that's the case, it'll encourage other big video game companies to not fear litigation of patents anymore and go after smaller developers that threaten their money, killing all competition and monopolizing literal game genres. So if you're actually outraged by what's going on, then hey, this might be a solution. Legally speaking, I have nothing to do with this, alright? So yeah, I wish Palworld the best. I hope Nintendo doesn't succeed in anything it's doing. Thank you so much for watching this video. I hope it helped explain the situation a bit more clearly to you. And make sure to check out the new drop that just came out on October 10th with Gamersubs that looks fantastic and will probably sell out in under 48 hours. Use the code MUJIN to get 10% off your total order. And yeah, I'll see you in the next video whenever that is. Probably about the 1,000 page document that Cinder dropped, but I'm not 100% sure yet. Love you so much. Mwah.